Good afternoon. This is the Board of County Commissioners Board Work Session. This is a regular meeting. It is Thursday, February 9th, 2023. It is 1:33 p.m. The session is set to go until 2 p.m. and I do have a hard stop at 2. This is a hybrid meeting. We're at 3000 Pacific Avenue Southeast, room 110. For public virtual attendance, you may follow along on the Thurston County YouTube channel. I'm Carolina Mejia. I'm the chair of the board. To my right is Vice Chair Ty Menser. To my left is Commissioner Gary Edwards. Also in the boardroom, we have County Manager Ramiro Chavez, as well as Assistant County Manager Robin Campbell, and staff from Community Planning and Economic Development to speak about the post-hearing briefing docket item A-19 wireless code update. So.
Thank you, Madam Chair. As you stated, we have scheduled only 30 minutes today. Certainly, there's not going to be enough time. Before the public hearing, the board had great questions, and hopefully today we'll give you a little overview of what you've heard and what you've heard. And at the end, hopefully we can get a little more specific as to what additional steps, what additional questions, and what additional reports you may like to have. But certainly today, we will not be asking you to make a decision. So just start from the beginning.
All right, Commissioners. So first, I'd like to just take a quick minute to recognize and appreciate Kate's professionalism and fact-based facilitation of this very difficult topic. I think Kate's done a really nice job of making sure that the board's needs have been met and that we've respected the board's hired attorney within the parameters of the legal questions that are raised. And I think kind of stepping back a little bit and always remembering our role as staff is facilitation of these difficult topics. This one obviously has a lot of input and interest. And from our perspective in CPED, it was staff's job to align with the board's hired counsel on this topic to give the parameters of the legal basis that the Planning Commission could then make a recommendation to the Board of County Commissioners. It was not within the Planning Commission's purview to go outside and make legal risk determinations. That's for the Board of County Commissioners from our perspective to go forward on. So Kate respected the guidance of the legal counsel, and that's what got us to the Planning Commission's recommendation that you received comment on just this week. So I just wanted to take that time to set the frame a little bit and say thank you to Kate for your great work.
Thank you.
So how would you like to proceed with going over the comments?
Well, I think you have a PowerPoint. So go ahead.
Sure. Good afternoon, Commissioners. Caitlin Nelson, Community Planning. In this briefing, it's intended as a follow-up to the hearing, but also to go over some of the stakeholder comments that were provided previously. As a general note, there have been several more recent changes to the code amendments, specifically to the special use chapter 20.54, but only in order to be consistent with the draft wireless communications code 20.33 that you've already reviewed. Next slide.
Could you just roll that back? You were up and down a couple times there. Just, that's fine. Go ahead.
Oh yeah, that's
Just
where
trying
it's
to
supposed to be anyways.
Just give me,
actually.
go ahead. So
Yeah.
let's just like.
I know. Go ahead. I'm listening. I'm just reading too.
The board directed staff to update code to comply with federal law, which regulates much of how wireless facilities are permitted. But in addition to the required changes, the code also incorporates additional aesthetics for facilities, specific application materials, and also identified priority areas for permits. Next slide.
Got it right here. I got it.
A public hearing was held on June 2nd with Planning Commission of 2021, which led to a stakeholder committee being formed at the direction of the board. After the stakeholder committee met 3 times, the Planning Commission held follow-up work sessions to discuss the concerns. And then Planning Commission made a recommendation with the minority report for the public hearing on the 7th this week. I am on slide 5. Okay. There were several themes in the public comments received. A request to require public comment and notice for all application types, require the testing of radio frequency emissions, increase setbacks, and create standards for facilities in the rights of way. And comment also stated some concern with the effects of radio frequency emissions on human health and the environment. Slide 6. Most of these comments were discussed at the stakeholder committee meetings, like I mentioned, and at Planning Commission. You have received a memo with additional details on these items as well. Okay, to start into some of those themes, one request that was identified was to create priority zones for certain facilities. Planning Commission reviewed this and then identified areas that deployment would be preferred. In order to incentivize those areas, Planning Commission also requested a change to specifically allow towers as an administrative permit instead of a hearing examiner review within those preferred zones, as long as all requirements were being met from the code. Another request that was made was to increase minimum setbacks and spacing distances. Planning Commission discussed this concern and did not request any additional changes at that time. The committee discussed testing all facilities for radio frequency emissions. Law prevents the county from basing any regulatory decisions based on environmental and health effects of radio frequency, from charging fees to applicants for testing, and from limiting radio frequency emissions more so than the Federal Communications Committee limits. However, the county may still test facilities to determine compliance with the FCC limits. As drafted, the code requires an attestation from the applicant that the facility will have radio frequency emissions under the FCC limits. And if a facility is tested and found to be higher than the set limits, the county would then report the facility to the FCC. It's uncertain at this time if the county would have the authority to require the facility to shut down. Another request that was made was to provide notice and solicit input from the community on all facilities. Certain permits, like those for smaller modifications or co-locations, must be approved or denied by the county within 60 or 90 days. Administrative permits at the county do not have a public notice and a comment period. While a hearing examiner review does, the timeline outlined for a hearing examiner review extends to about 150 days. To incorporate public notice and comment period for these types of projects, a new permit type would need to be created. Additional standards in the right-of-way were also requested. And at Thurston County, standards for facilities in the right-of-way are located in the road standards or in franchise agreements. The road standards are updated by the Public Works Department, and those updates have a public input process and board approval process as well. And then there are numerous other requests that generally fell into the category of either creating inconsistencies with how the county permits land use permits and applications, or adding significant additional staff time for review. So at this time, I am requesting either direction from the board, or I can respond to any questions.
Okay. I guess we're ready to move forward, but Commissioner Edwards, I know that you had questions. I know Commissioner Menser had some questions. So we'll go ahead and start.
I didn't hear anything about litigation, the problem we might face if we don't do certain things. I don't know. I mean, if we don't appease corporate America, I guess I'll put it that way, what kind of litigation are we up against?
We're not in the position to answer that question, Commissioner. That's for some of the questions they would like to take notes and bring legal counsel to answer those questions.
Okay.
And certainly that is a valid or good question, but we need to have an executive session for you to have those conversations.
Okay.
Okay.
How about on the radio frequency, we can't consider health issues because that's been decided in a federal court or something somewhere that there's enough information on that, and we as locals don't have any authority over deciphering that. Is that correct?
That is an accurate statement. The federal law prohibits us from requiring anything beyond what is written in that federal law.
How about, there were several comments at the hearing, and they made reference to several jurisdictions, and I believe they were out of California. One of them was, I don't know the pronunciation of the town, Palo Alto, maybe,
Palo Alto.
Petaluma, Palo Alto.
which is a, what?
Petaluma?
Down where the Rose Bowl was held.
It's down in South Cal.
Where?
It's down in Southern California.
Yeah. Yeah, I guess where the Rose Bowl was held, that's all. I
Pasadena?
know.
Pasadena?
Yours was in Pasadena.
Palo Alto, I thought.
It was Palo Alto, they highlighted that city along.
That was one of them. Okay, and so they've got an ordinance that satisfies these complaints brought forward by the citizens the other day. Is that right? I mean, is that what I heard that, that's what they were saying.
So if you'd like us to explore the different comments, we can.
Well, yeah, I just wonder, why do we have to reinvent the wheel? And then, but that comes back to our liability exposure, because under the information they presented, and I got some information from one of the folks testifying there about if we lose, if we get sued by corporate America and we lose, the penalty is not you have to pay their legal fees or pay a fine or anything. You just have to, they get to go ahead with whatever the federal regulatory process is. So, and our penalty is what it cost us to bring the action to defend, I guess. So we'd have some time invested in attorneys at our own level. But other than that, they said there was no exposure. Now, I'd like to know more about that, but I need to get that answer from somebody besides you guys so we get it right. But what I'm wondering is, if there's any validity to that statement, let me just put it that way, then why couldn't we adopt an ordinance that has been already reviewed and put in place by another jurisdiction that seems to be successful? And I say seems to be because I don't know exactly, but why wouldn't that be feasible? I don't like to reinvent the wheel ever. I know we've got a lot of work into this. And to be honest with you, it's a learning curve for me because I'm a slow learner. I guess I'll just put it that way.
You also heard testimony later on about those jurisdictions. They have been, they're under litigation.
Yep, that's
They-
right.
And they have not settled those litigations, but I don't know. So I think it was the two sides of when you heard those testimonies.
But there is, and I read it, I have it right, I've got it here somewhere in front of me. There is federal law that limits what, I've got it over here. It limits what the exposure is. Federal law mandates cases proceeded on an expedited basis, I guess. Such cases typically last months rather than years. As a result, the attorney's fees incurred by local government are typically quite small. Okay, if we have our own people do it, compared to virtually any other type of federal litigation, as long as the local government council does not try to maximize its billing in the case somehow, and that
Sorry, what
Compensate.
are you reading, Commissioner?
So I can tell you that the lawsuits that we have been party to regarding wireless communication and FCC codes, no one in our prosecutor's office has any area of expertise, so we went with Mr. Fellman and his law firm, and it was tens of thousands of dollars. It wasn't hundreds of thousands, but it was
a
still no
class action.
small amount, And that's when we were only one of many parties.
Yeah, and it went all the way to federal district court, and because the lower courts
And
didn't,
the locals lost.
we lost. And so.
What did you lose? What did we lose?
Because we were
Any
challenged,
ability to do anything that varied very far from the
because you're right,
federal code.
if I take you back maybe 5, 6 years ago, when these new regulations came, we embarked on a class action lawsuit across the country with many local jurisdictions challenging those federal regulations. We lost.
And
we
what
lost
what
the
did that
challenge.
mean? We lost, what did we lose?
So the
Mr.
federal
Fallon,
Monetary
to
amount?
fill you in.
Well, no, I mean, we have to know if we lost money or not.
Well, that's that we lost money. I mean, we lost the money on funding the
Attorney fees.
attorney.
Yeah. But did we have to pay $1 million or,
Lost your ability to write more restrictive code
well, then
which
why,
is what you're
then why are we doing this?
proposing.
I guess that, if we lost that, why are
But
we doing
what
this?
the code that your staff and Mr. Fellman have proposed to you is in accordance with federal law. What your stakeholders are proposing is not. In a nutshell, just to put a fine point on it.
So, yeah, go ahead. Sorry.
Well, I mean, I have to take issue with that because just take one issue. The compliance with radio frequency emissions. We're not allowed to increase that or reduce that limit, but you said that we have the ability to test. Now, do we want to pay for that? I don't know, but the stakeholders are saying, we want to make sure that you don't just let them file an affidavit and we just take their word. We want you to come up with somebody at the, so that's something that we're allowed to do under federal law. Now, maybe we can't afford it or we don't want to bother with it, but it's not something that it's illegal for us to do. In fact, in New York City, they just handed me one of the guys at the hearing handed me an article from the New York Times saying that New York City has done exactly that. And they're doing independent third-party testing of the total RF emissions. And so, I mean, it's doable, it's legal, it's not free. So, and I think we're probably precluded from, one of the people said, well, you can just charge fees to pay for that. And I don't think we can do that. I think the law says we're not allowed to just raise the fee for the application so we can pay for the independent testing. That's off limits, but it is something we could consider doing. No, the setbacks is a big thing. So I looked up some of the facts that were proffered at the public hearing. That person from the wireless community is correct that 1,000-yard thing is 72 acres. That's not, I don't think that's reasonable. I don't think it's possible to, in an urban area, to say you couldn't have, you know, everything, they ought to be 72 acre like separation swaths. You wouldn't have anywhere to put them. So I don't think that's reasonable, but I was hearing that, you know, some of the, and I know there's different facility types, so I'm getting a little confused, but in some cases, it's like 10 feet from residences, and that seems pretty unreasonable to me too. So, you know, and the comment period, the notice and comment, it doesn't sound like that would run afoul of federal law to, as you say in this slide, create a new permit type to allow public notice and comment so that we can meet the 60-day timeline. We can do that. If we think the public, if that's valid, we can do it. So, I mean, we lost our ability to probably go, you know, do a lot of stuff to rein in. So now we're down to these few little tools that we're left with that the prior litigation allowed us. But I do think there's some latitude within what's left for us to control. I don't want to do anything that's unreasonable. I don't think 1,000 feet's gonna fly, but I see some of this other stuff as perfectly reasonable. And I'm frustrated because, and there's nobody to blame about it, but whether it's the consultant being too conservative or staff mishearing the consultant or the planning commission mishearing the consultant or the law, I mean, clearly the process, you know, we hired a consultant and we started a stakeholder group, both for the purpose of the board, which is an unwieldy type of a organism to fine tune a very technical code, to not have to be in this position. And after all this process, here we are where these key elements that I think are within our control, the process was such that the planning commission or the stakeholder group was saying, no, that would have to come from the board. Well, okay, I mean, then now here we are. So now it's on our lap. Well, I wanted that process to vet those issues. I didn't want them to be told that's something they couldn't go through. I wanted recommendations from them. Now we're left where all the underpinning of planning commission and stakeholder group that I was hoping to rely on to give me a good set of balanced recommendations, it's all back in my lap. A stack of, that's where I threw my paper down when I came here, because I've tried to go through this week and I've started creating an issue by issue memo, and I'm already lost. And there's no way that the three of us, I mean, I'm lost individually, and there's no way the three of us are gonna be able to rewrite this code in a way that balances the legal constraints with the community concerns. We just can't. So I don't know. I mean, two of the planning commissioners said, send it back to us. I went up to one of them after I said, are you really want us to send this back to you? I mean, you know, I'll do it, but I'd rather just, you know, I'd rather get this done, but I'm not trying to delay it, but I can't just vote for what's here when there hasn't been thorough vetting of what discretion we do have under the law and whether it's good policy or bad policy. Let's just take public comment and notice. Is it good policy or bad policy to allow, within that very tight 60-day shot clock window, folks to be noticed, a certain amount of people? I don't know if it's a mile, if it's a half mile, if it's a block. But do the people right around there, at least, you know, 500 feet away, deserve to know something like this is going up? I think there's enough community interest in this that does make sense. But, and it's not illegal, but yet we don't have any recommendation for that from the planning commission. It's like, I don't know what that number ought to be.
I do have a suggestion.
So I'm just frustrated. I don't know how we're gonna get to the finish line on this, given all of the strikeouts that we've had with this process. And to have two planning commissioners come and basically tell us, you know, that the process was deeply flawed, and it was frustrating.
I'm right there with you, and I share Commissioner Mentzer's concerns really to the T. I was hoping with the stakeholder group, right? Like when they came in and we were like, okay, let's send it to a stakeholder group. I thought what would come to us would be a set of recommendations of like, kind of, this is the scope that you have, but instead, it just seems like, again, we have this huge stack of papers and, we have just public comment and public concern. We have planning commissioner concerns. And I don't know if I feel like we really didn't get kind of anywhere. I feel like we're back to where we were before we decided to go ahead with a stakeholder committee. That's kind of where I feel like we're at once again. Commissioner Edwards, you said you wanted to say something.
Why is it that we couldn't take an ordinance that's been suggested, see if it fits? Why do we have to reinvent the wheel if we don't have to? And the county manager asked me what I was referring to, and it's out of the, this is a public comment that came in, so I'm just gonna quick regurgitate that. All too often, representatives of the wireless carrier and or site developers seek to intimidate local zoning officials with either open or veiled threats of litigation. And that's kind of what it's talked about. These threats of litigation under 1996 Telecommunications Act, TCA, are for the most part entirely hollow. Now that's somebody's opinion that came forward. I'm not saying that's true or not true, but I would like to know more about that. How hollow are they? And this is because even if they file a federal action against the county and win, the TCA does not enable them to recover compensatory damages or attorney fees, even when they get creative and try to characterize their cases as claims under 42 USC 1983. I guess that sounds like civil rights stuff to me, but anyway, why can't we bring in an ordinance from elsewhere that seems to have, has it satisfied all parties? I don't know that, so that, I can't say that. But maybe it sounds like it's a compromise that might allow things to move forward. And the one comment that was made that really got my attention is, here we are as a county trying to supply high-speed capabilities by wire to all our citizens, or as many as we can possibly reach. And that kind of alleviates some of the need of these corporate outfits. And that makes it look to me like it's all about money. Okay, if we don't do that, then these folks can't sell a service.
So,
So,
Can I jump in real
as a
quick?
point of clarification, they made a point of having this quality tribe broadband project. Is all underground? That's not correct.
No, some of it's overhead.
so Commissioner Mintzer, Commissioner Mejia, I think you have a hard stop at 2. So I want to make sure that we clarify something real quick, because from our perspective, we're not back where we started. If you look at the page 7, it very clearly states the scope, stakeholder request, changes were made. And then the next slide, stakeholder request, no changes, this is within scope. So it's that top blue line. The next stakeholder request, that's the legal opinion that it's outside of scope. And the next one is the legal opinion that those are outside of scope also. And so if you look at those, we broke it down, just like Commissioner Mintzer asked at the beginning of the hearing. Please just line all these topics out generally for us and show us what we can or cannot do. And then we'll make the decision on where we think we want to push. This is that chart. So use that as your guide when you're considering where you want to go next. See that you've got recommendations from your lawyer that it's within or without of scope. And we've got the topic and what potential changes could be made.
Who set the scope?
The lawyer. I'm sorry, say it again.
Why would the
What-
attorney
legal.
set the scope?
Legal parameters. That was the scope.
So I may probably suggest a different path.
That's great, but I just want to make sure that we're not.
I don't
back where
think
we
at this
started.
point the board is ready just to go down the
Totally.
chart and determine what you like to do. I think there is a couple of questions that you certainly needs to be answered from the legal point of view. We need to bring Ken Feldman to have that conversation with you in the executive session for you to answer all those questions. He answered all those questions. And I think that's a valid question. I think what you're asking is, what is the latitude? What is the latitude the board has? And I think it's also, Ken Feldman will be in the position to provide you that feedback. Because there's no internal attorney who has the level of expertise. And that is why we had to hire Ken Feldman. And Ken Feldman is knowledgeable on this business, so.
I would ask for information. So the first one that we heard about was Langley. I didn't even know where that was. I had to go on my, Google Maps. Yeah, and then, but when you throw out Palo Alto, that is the epicenter of Silicon Valley. There would be no better place to see where there would be massive amounts of money, corporate interest, wireless companies. So if something passed muster in Palo Alto, it's probably good.
Yeah, we could probably look.
So let's look at them.
Yeah,
Oh, for sure.
that's the third part that I was gonna ask. We're gonna be looking at some options, but with all due respect, I don't think it will be fruitful to bring an ordinance from a California, Palo Alto, and put it in Thurston County, call it
I
good.
disagree with you. I think it's worth
So,
looking at.
because state law is different.
I don't
Our
care.
code is different.
We follow a lot of California activity. I don't always agree with it, but.
Going on that same line, and I have to go here, but, like Palo Alto, San Diego County was another one.
Yeah.
And I know that there's some litigation with some of these. I would like to know, like, okay, which ones are being litigated, right? If some of them are resolved, I would like to know which ones won and which ones had to go back and change their code, is kind of like questions that I have for Tim Feldman in terms of other county codes. Because I feel like that will give us a clearer line on these scopes that we have to go through in terms of public comment, in terms of testing. And I think those are the major questions that we have, like if other counties were able to do it, and we have more of that scope on there, and especially if some of them won, like, I would wanna know that, right? Because there's less of a risk for us if there's already a precedent set from another county where they've already gone through this process, they've already gone through the court system and they've won. And we do have that scope, right? And I wanna know that information when we talk with,
Yeah.
Mr. Feldman.
Or
It's
I
all
want to
good.
know if they lost and what
Yeah,
happened.
Yes.
So it's all good. We'll organize a coordinated meeting with Ken to come have a conversation with you. To answer your question, do we have a deadline to do it? I mean, we're way behind this, so I think you still have some time to take an action.
Our deadline is the confusion at the permit counter. Given that we, or the board, hasn't set parameters, the people, when they come to apply for these, are using the more broad FCC regulations, where we don't have any control over their applications at all right now.
But
So
if
that's-
that's what they are able to do, that's what they follow the law and do, I guess.
You're also negotiating franchise agreements with these companies. And we've been doing short-term agreements in
That's right.
anticipation of the wireless code being updated. So we have just.
See, and that is probably in a franchise agreement, we allow them to remain in the right of way at no cost. And that is one of the elements as to how we can probably put our hands around in this process a little bit. Because they can go with the federal law. Absolutely, and we will have no say.
What is the, how many of these applications are there?
Check.
I'm curious.
So we'll organize this, more to come.
So,
Thank you.
2:03, we're adjourned. Thank you all.
Thank you.